Welcome to the Deep Dive. Today we're jumping into something huge, something really shifting under the feet of, well, hundreds of thousands of people globally. We're talking about the rules around U.S. student visas. They're changing quite rapidly.
They really are. It's a landscape that's evolving almost constantly, it seems.
Exactly. And this deep dive is really for you, the current or maybe future international student, to try and, demystify some of these shifts. We're talking policies, screening, what it all actually means day to day.
Our goal here is to unpack the big updates, things like proposed visa term limits, which is a major one.
And the new social media checks everyone's talking about. Plus, just the basics, well, not so basic anymore, of keeping your student status valid.
We'll look at the real-world effects, the economic side of things too, and hopefully offer some solid insights for navigating it all.
Okay, let's unpack this. Where should we start? Maybe with that fundamental shift,
Yeah.
the fixed term limits.
Yeah, I think that's the place to start. It's a really significant proposal from the Department of Homeland Security, DHS. They're looking at possibly replacing the current duration of status system for F1 and J1 visas.
Right. Duration of status basically means you're good as long as you follow the rules and are enrolled, yeah?
Exactly. F1 students, J1 exchange visitors, even I-1 foreign media folks, they currently have this open-ended stay, provided they comply. No fixed end date tied to the visa itself initially.
Okay, so what's the proposed change then?
The proposal is to switch to fixed time limits, predetermined periods, likely somewhere between 2 and 4 years.
2 to 4 years. But hang on, what about PhD students? Or longer undergraduate programs? Many take more than 4 years.
That's precisely the issue. If your program goes beyond whatever fixed term limit is set on your visa, you'd then have to apply for an extension. And that application would go through USCIS, United States Citizenship and Immigration Services.
Ah, USCIS. So more paperwork, more process. Has this moved forward at all?
It has. It actually cleared a key White House review back on August 7th, 2025. That basically clears the path for DHS to publish it officially in the Federal Register. Then there's a public comment period, usually 30 to 60 days.
Okay, so it's not law yet, but it's definitely on the table.
Yeah.
What are the potential impacts? It sounds like more than just an inconvenience.
Oh, definitely. First off, you're looking at increased bureaucracy, more forms, potential delays waiting for USCIS, and almost certainly more fees for each extension.
Right. Multiple applications potentially for just one degree.
Exactly. And think about the disruption, particularly for long-term programs. PhDs, especially in STEM fields, often need 5, 6, maybe more years. Suddenly introducing these mandatory check-in points, these renewal hurdles, it adds a layer of uncertainty that just wasn't there before.
And I imagine the universities aren't thrilled either. This must create a huge administrative load for them.
A massive one. Universities, the program sponsors, they'd likely need to completely overhaul their support systems. New tracking, new advising protocols, helping students manage these deadlines.
It feels like it could discourage students from even applying to the U.S. in the first place, if Canada or the UK seems simpler.
That's a real concern. The added complexity, the uncertainty. It could absolutely make the U.S. less attractive compared to other countries, impacting our ability to draw top global talent.
Okay, so that's the potential shift in visa duration. But there's another layer of scrutiny that's already in effect, isn't there? Social media.
Yes. This is a big one, and it's already here. Effective June 19th, 2025, there's mandatory social media screening for pretty much all non-immigrant visa applicants. That includes F, M, and J student visas.
Mandatory screening. How does that actually work? What do you have to provide?
On the visa application form, the DS-160, you now have to link your usernames or handles for social media platforms you've used in the last 5 years. And the expectation is that you set those accounts to public so consular officers can review them.
Public. Wow. What exactly are they looking for when they review these accounts? Is it about specific keywords or?
The stated purpose is, and I'm quoting roughly here, to ensure we are properly screening every single person. They're looking for any indications of hostility toward the citizens, culture, government, institutions, or founding principles of the United States.
Indications of hostility. That sounds broad. Subjective, maybe.
It can be. And the list of platforms they mention is long: Facebook, X, Instagram, YouTube, LinkedIn, Reddit, TikTok, Snapchat, Pinterest, Tumblr, even Douban in China. And they say the list can change.
So if you have an old MySpace account somewhere, or maybe a secondary Instagram, a Finsta, do you list those too?
The advice is absolutely yes. Do not hide or misrepresent anything. List all personal accounts. even inactive ones, deleted ones, those secondary accounts. They don't ask for passwords, it's only publicly visible content, and you don't need to list, say, business accounts. But concealing personal accounts, that's a huge red flag. Honesty is key.
This focus on screening seems to tie into a broader trend, a sort of zero-tolerance approach mentioned recently.
Yes, U.S. Consul General Laura Williams mentioned that on August 13th, 2025. Zero tolerance for lawbreaking, expecting students to comply with U.S. laws. But what's interesting is how the definition of lawbreaking seems to be expanding, or at least the grounds for visa action are.
Expanding how? Beyond actual criminal convictions.
It seems so. We're hearing that politically controversial posts, maybe strong criticism of U.S. policy online, or even links to certain protest movements, these can be flagged. They could potentially be used as grounds for denying a visa or even revoking an existing one.
Revoking a visa based on a social media post.
It appears that way. There's talk of this catch and revoke program reportedly from Donald Trump's second term. It supposedly uses AI to scan digital footprints for activism or support for causes deemed controversial things like Palestinian human rights advocacy, or maybe calls for political reform back in China.
And this is actually affecting students.
Reports suggest hundreds have been affected, particularly students from India and China. Their digital activity is being scrutinized in ways it wasn't before.
Wow. And it's not just online activity, right? There's also increased use of the FBI's crime database, the NCIC.
That's right. Consular officers and immigration agents seem to have broader discretion now to use the NCIC database as a primary screening tool for visa revocation.
Okay, but what's the problem with using a crime database? Isn't that standard?
The issue is the NCIC database itself. It doesn't really distinguish between serious felony convictions and much more minor or even irrelevant records. Think about arrests where charges were dropped years ago, or decades-old misdemeanors, minor traffic stuff. Even cases of mistaken identity can end up in there.
So any kind of flag in that system, regardless of the context or outcome, could be used against a student's visa.
That seems to be the danger. A minor incident from the past, maybe something completely resolved or irrelevant, could suddenly become grounds for visa denial or revocation. It casts a very wide net.
We've actually seen some specific cases hit the news, haven't we?
We have. There was Badar Khan Suri, an Indian postdoc fellow at Georgetown. His visa was challenged partly over social media posts, but also his marriage to a relative of a Hamas advisor. His lawyers argued it was protected speech and association, but it caused major issues.
Right, and the Turkish PhD student.
Rumeysa Öztürk at Tufts. Her visa was reportedly canceled over an op-ed she co-authored on a political topic, again raising questions about academic freedom and expression versus visa eligibility.
It really highlights how the standards can be different for international students compared to U.S. citizens, even regarding speech.
Absolutely. What might be considered protected speech here can have serious immigration consequences if you're on a visa. It's a critical distinction.
Okay, let's shift gears a bit to the operational side, getting the visa in the first place. We're hearing about major delays, especially for students from India applying for fall 2025.
Yes, that's a huge bottleneck right now. Thousands of Indian students are facing really long wait times, very limited appointment slots. It's causing a lot of anxiety.
What's causing it? Just high demand?
It's kind of a perfect storm. Record numbers of applications in 2025, especially from India, which sends a huge number of students. Add to that staffing and capacity limits at U.S. consulates, maybe some lingering processing delays from the pandemic. It all adds up.
Do we know roughly what the wait times are like?
The averages are stark. For an F1 interview, New Delhi might be 45 to 60 days wait. Mumbai, maybe 55 to 75 days. Hyderabad, potentially over 60 days. Chennai, around 40 to 55. And these are just averages. The reality is when slots do open up, they can be gone in minutes. It's incredibly competitive.
So if you're a student trying to get an appointment, what can you actually do? Just keep refreshing the page.
Pretty much, but strategically. The best advice is book any appointment as soon as you get your Form I-20, even if it's months away. You can always try to reschedule if something earlier pops up.
Okay, grab a spot first.
Exactly. Then, use multiple devices, check the portal frequently. Some find success checking very early morning or late night India time when new slots might get released. Using alerts or tracking services can help too.
What about emergency appointments?
Those are an option, but only if you genuinely meet the criteria, usually meaning your program start date is very close and you haven't been able to get a regular slot. You need a strong reason. It's not a shortcut for everyone.
Stepping back again, all these hurdles, The potential term limits, the intense screening, the appointment delays, this must have a wider economic impact on the U.S., right?
A significant one. NAFSA, the Association of International Educators, along with JB International, put out research projecting a potential drop of 30 to 40% in new international student enrollment for fall 2025 because of these issues.
30 to 40%, that's massive.
It is, and that translates to about a 15% drop in overall international enrollment, the economic fallout. They estimate nearly $7 billion in lost revenue for the U.S. economy and over 60,000 fewer U.S. jobs supported by international students.
$7 billion and 60,000 jobs. That really puts it in perspective.
It does. It impacts tuition revenue, housing, local businesses, everything. NAFSA is strongly urging Congress to protect funding for international education programs and pushing the State Department to get visa appointments back on track, not just for the students, but for the U.S. economy and, frankly, national security through global engagement.
Okay, so assuming a student gets through all that, gets the visa, arrives, the next challenge is maintaining that status. Let's talk SEVIS.
Right. SEVIS, the Student and Exchange Visitor Information System, it's the government database that essentially tracks your legal status as a student here. Your school has designated school officials, DSOs, who manage your record in SEVIS. They update it, authorize things, but they can also terminate it if you fall out of status.
Terminate the record. What happens then? What are the immediate consequences?
It's serious. Your SEVIS record gets terminated, you immediately lose any authorization to work, whether on campus or off campus, CPT, OPT. You can't use that record to re-enter the U.S. if you leave. Immigration and Customs Enforcement, ICE, might even start looking into whether you've actually departed the country. And if you have dependents, like a spouse or kids on F2 visas, their status gets terminated too.
Is there any kind of grace period if your record is terminated?
This is important. If it's terminated because you violated your status, like working without authorization or non-enrolling full-time, there is no grace period. 0 days. You either have to leave the U.S. immediately or apply for reinstatement, which is complicated.
But what if it's not a violation? Like an authorized early withdrawal?
In that specific case, for F1 students who get an authorized early withdrawal approved by their DSO, there's a 15-day grace period to depart the U.S. But that 15-day period doesn't apply to M1 vocational students, only F1.
And there was something about ICE gaining new power to terminate SEVIS records directly, bypassing the school.
Yes, that's a relatively new guideline from 2025. It seems to give ICE the authority to terminate a student's SEVIS record directly if the student's visa is revoked. Critically, this can happen even if the school itself hasn't found any violation of student status rules. The visa revocation itself can trigger SEVIS termination by ICE. It's very direct, very fast.
Wow, okay, so the link between visa status and SEVIS status is even tighter now. Let's shift to something hopefully a bit more positive. Practical training, OPT, and CBT. Any updates there?
There are some updates, mostly around STEM OPT, the 24-month extension for science, tech, engineering, and math grads. The good news is that extension is still firmly in place.
That's good to hear. Any changes to the rules for it?
A couple of notable ones. They've actually eliminated the requirement for employers participating in STEM OPT to be enrolled in E-Verify. That was a hurdle for some smaller companies. Employers still need to submit a formal training plan, the Form I-983, outlining the training goals and supervision.
Okay, less employer burden there. Anything else?
Yes, reporting frequency for students on STEM OPT has been reduced. Instead of checking in every 6 months, it's now just annually. And the total number of unemployment days allowed across your entire OPT period, initial OPT plus STEM OPT, has been increased slightly, from 150 days total to 180 days. A bit more flexibility if you're between jobs.
Any changes on the fee side? There's always a fee.
Always a fee. Yes, the application fee for the STEM OPT extension using Form I-765 went up slightly. It's now $470 if you file online and $520 if you file by paper, up from $410 previously.
Okay, good to know. Now, a common and really serious way students get into trouble is unauthorized work. Maybe working a day past their CPT expired or continuing an internship after OPT ended.
It happens sometimes unknowingly, but the consequences are severe. If you work without authorization, even for a short time, your I-20 becomes invalid for future OPT or getting your EAD card. It basically torpedoes your immediate post-graduation work plan.
So if a student finds themselves in that situation, maybe they made a mistake, what are the options? Is there any way back?
There are options, but they're not easy. One path is reinstatement. You apply to USCIS while still in the U.S., arguing you should be put back into valid F1 status. You need to meet specific criteria, like proving the violation was due to circumstances beyond your control, or that not being reinstated would cause extreme hardship. It's not guaranteed.
Okay, reinstatement. What else? I think you mentioned something called a border hop.
Right, the border hop. It's not about sneaking across, it's a procedural thing. Essentially, you need to get a new initial Form I-20 from your school. This might even mean starting a new degree program. Crucially, if you want to regain eligibility for OPT later, that new program usually has to be at least one full academic year long.
So get a new I-20, then what?
Then you physically leave the United States, maybe a short trip to Canada or Mexico, and you re-enter using that new I-20 and a new SEVIS record. You'll have to pay the I-901 SEVIS fee again. This process basically resets your F1 clock. You're starting fresh in terms of status and benefits eligibility.
And when you're at the border trying to re-enter on that new I-20, honesty is the best policy, even about the previous issue.
Absolutely critical.
Yeah.
When you go through Customs and Border Protection, CBP, especially if you end up in secondary inspection, being 100% truthful about your situation, including any past status violations like unauthorized work, is paramount. Trying to hide it is a really bad idea and can lead to being barred from entry. Officers generally appreciate honesty, even if it reveals a past mistake.
And what about getting legal advice for these situations? Is an immigration attorney helpful?
There's actually some differing advice out there. Some argue that for clear-cut violations like unauthorized work, the consequences are pretty fixed by law, and an attorney might not be able to change the outcome, potentially being a waste of money. Others strongly advise consulting an attorney, given how high the stakes are. Your entire ability to study and work in the U.S. is on the line, and the complexity of immigration law. An attorney can help navigate the options like reinstatement or prepare you for the border crossing. It probably depends on the specific circumstances. So just to quickly summarize where we've landed after this deep dive, we've really seen some major shifts. Proposed fixed-term visas potentially replacing the long-standing duration of status, new mandatory social media checks becoming routine, a broader interpretation of what constitutes law-breaking offenses, and now including online speech and even minor past records flagged in databases like NCIC.
Right, and we touched on the very real operational problems, like those huge visa appointment backlogs, especially in India, and the significant economic ripple effects NAFTA is warning about billions in lost revenue, tens of thousands of jobs.
Exactly. And then the critical importance of maintaining that SEVIS status once you're here, understanding the severe consequences of termination, the lack of grace periods for violations, and that new power ICE has to terminate records directly if a visa is revoked.
Plus, the details around practical training updates and the potential pitfalls of unauthorized work, along with those tricky options like reinstatement or the border hop to try and fix things.
It's definitely a more complex, more demanding landscape for international students now. Careful attention, being proactive, it's essential.
So what's the big takeaway for you, the listener? It's clear, isn't it? The U.S. absolutely remains a top destination for education, but the rules of the game, they're stricter, more complex, more scrutinizing than ever before. Being informed, being meticulous about compliance, knowing the potential traps, it's not just good advice anymore. It's really survival R&R in this new environment. And it leaves us with a big question, doesn't it? In this era of, heightened scrutiny and tighter controls, how do we strike that right balance? How do we protect national security while still fostering the open exchange of knowledge and talent that's always been such a strength for international education and for the U.S. itself? It's something to think about. All the best, and we will meet again with another important matter in the next deep dive.